Reincarnated, I'm a stargazer. Life goes on, honey, to all my babies. Looking for the broccoli, I keep a horn on me, that come my seat. I peep ownership, the blueprint is by me. Let the bit off, I get off at my feet. A yeet nigga couldn't try me in a tri-state. Money pass, bet I get him splash. Down south, know me spook town, eyes dilated. I got the money and the power, both gyrate. I look good, get the fuck out my face. Look good, but she don't got no ties. I walked in, walked out with the size.
To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already fooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir, you said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again,
We all
you asked
disagree.
questions to lay a foundation
All of a sudden, the
with
state
these
don't
I
got
told you,
witnesses.
facts
all of a
not
sudden,
found in
for
evidence,
the
baby.
first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this
and
is
not-
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I just
commentary
want
at this
that on the
point.
record. I see through it. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up. So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to
of
be
the-
said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back? I got one ear that work, and I heard that.
This
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice.
So can
Your
you
Honor,
tell?
I
Can you
believe he
please?
has 7 prior convictions via my second.
I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking
And then you have the have the flagpole, like in the hearing. Oh my gosh, I love it. Hey everybody, Kayla, Sierra, Lisa Ann, Daniel Barrett, Sports Highlights, Muffins, Mink. The hell? I'm tripping. Okay, Muffins, Mimi, and Oscar's wife. How's everybody doing this evening? Oh, hold on, let me get us on the screen. Lord, I don't know where nothing go. I'm sorry, y'all. Y'all know I got problems. I'll remove. Here we go. All right, yeah, put me on the bottom. All right, that's fine. That'll work. How's everybody doing this evening?
I'm pretty sure nobody wants to see my ugly mug, you know what I'm saying?
And people want to see your ugly face.
Mhm.
They love you, Michael.
They think I'm all right.
You all right.
Yeah, he all right.
Thank you, Sierra. So yeah, hey Charlene. Yeah, I was in the bed all day, Friday and Saturday. I started feeling a little bit better because it's weather change. And if y'all are not from the South or Alabama, our seasons are spring and summer, and then summer lasts all the way up until October, and then we have fall but it's actually just a continuation of summer. And so then we'll get it'll get cool like in January, and then we already starting with spring. The trees blooming. I said I want to ask my supervisor if I could work remote from now until October because of my sinuses, and see what he say. I'm pretty sure that wouldn't fly. But anyway, we're gonna start with Box Fort Day, and if I feel like it, I want to show Mike the COVID test foolishness. But I don't want to be up here for too long because I am a little bit tired. I'm in my sleeping attire, so all I gotta do is roll my hair. I'm ready for bed. For those of y'all who like documentaries, I highly recommend you go to Netflix and watch the Top Model documentary. It's very interesting, and
Yes, gets
yeah,
my seal of approval as well.
it's only 3 episodes, so that's 3 hours total.
Mhm.
And I won't spoil it, but Tyra took zero accountability for anything that she's done. And she is saying that there's going to be a cycle 25, which I don't understand how that's going to occur with all the stuff they did.
Mhm.
But hey,
Yeah. Also, spoiler alert: Tyra Banks is crazy as sin.
she is. She's a demon.
Yeah.
She's a demon.
Mm.
And the thing, the thing that pissed me off about Tyra is that she held herself out to be a mentor for these girls. And, I just want to have these people that would not necessarily make it in the modeling industry. And I wanted y'all to see a behind the scenes look at what was going on. And seasons 1 and 2, yeah,
Yeah.
that was seemed like that
I
was the intent.
Yeah, I think they do a good job of basically like I think that's how it started out. I think deep down in her heart, you know what I'm saying, that was the plan originally. But one of the things that keep sort of mentioning in the documentary is that like, hey, you do a crazy thing, the next season you got to do something even crazier. And then the
Mm-hmm.
season after that, you got to do something even crazier. And then, after, about 6 or 7 seasons, you know what I'm saying? You're doing like the wildest shit
And
that
they
makes
did.
zero sense.
Yeah, like the race swapping
Yeah.
episode,
Hold
that
on.
was
But here's the
crazy.
here's the crazy thing. And maybe it was just the times. You know what I'm saying?
Yeah.
Like maybe people didn't think about it too tough back then, you know what I'm saying? Because I was a top model dude back in the days. I was watching all them shits, you know what I'm saying? So like when I saw it, I didn't really think anything of it. But somebody should have said, like, yo, we probably shouldn't be doing this. This is not the right thing to do. But not only did they do it once, they did it twice. So obviously, nobody said anything about it. Nobody said like, "Yo, man, we that was a bad thing to do, but we got through it without catching too much slack." You know
Yeah,
what I'm saying? Unless somebody's like, "Well, we did it one time and got away with it. Let's
let's
do
do it again.
it again."
Basically.
Mhm.
Let's say, hey, Oscar. I think I spoke to Oscar's wife, Stitcher and Tara. All righty, but it's highly recommended. And I will say that I thought back in the day when the stuff was occurring, how it is when you watch Making the Band now, and then you
Mhm.
just like, man, that was some trippy shit.
Yeah, because it's different
Puff
time.
was a demon.
That was a different time. Yeah, I mean, like I think we talked about this on one of the things where it's like, yeah, when you look at it now, you're like, man, that shit's wild. But back then, it was like, man, that was what people was doing.
Look,
No
I
big deal.
understood the logic. I understood the logic, and I didn't really read it as blackface.
Right,
But
exactly.
like
I did
today,
the
it's
same thing.
blackface. It's
Yeah,
totally blackface.
yeah. Today, I'm looking at that like, man, that is insane. How did anybody not say anything about that? But I remember watching that, and I thought zero of it. I was like, oh, that's very creative.
Right. Or the episode where they were like posing in graves, and it was like different ways that the models die, and
Yeah,
you had like somebody with
the
schizophrenia.
murder crime scenes or whatever. Like
Yes.
nobody was like, yo, this is way over the top.
But I did notice though, just like with American Idol and all these The Voice, the
Uh-huh.
winners, the winners are not as successful as you think that they should be.
Yeah,
And the girl that had the gap, Danielle, that she
yeah,
won, but she said, and this broke my heart to hear.
yeah.
She said that they would not allow her, like designers would not put her in shows because she was considered a reality TV star,
Hmm.
and that Tyra admitted to her that she knew that the girl was struggling, and she knew that, quote unquote, there were certain doors that she would not be able to get into because she was on Top Model. And Tyra said, I didn't do anything to help you. I'm just like, wow.
Hmm.
And you want to start a cycle 25? With who? The three people that made your show, Mr. J, Miss J, and Nigel, are gone.
Oh man, Miss J broke my heart at the end of it, man. I
Mm-hmm.
was like, oh man, I felt so sorry for him, man. I was like, oh man, oh.
Yeah. And bitch, how come you have no interest in talking to the person that you claim taught you how to walk when you were a teenager,
Hmm.
that you brought in to the show?
Yeah,
And you can't even send a text message? I'm sorry. You can't bring your ass from wherever you are
yeah.
and and see. I mean, see about your friend, alleged friend,
I mean, like I say, he basically made
the
who
show.
she is. Well, no, not even
Yes.
just the show, just her modeling career. Because, like I
True.
said, she admitted that, like I said, she learned everything she learned from Miss J. So, like I
Hmm.
said, for him to be down and you don't show up at all,
At all.
you know what I'm saying? I don't like people like that, man.
Me neither.
Them peoples you got to get out your circle.
Trifling hoes. But
Hmm.
anyway, watch it. It's good. Hey, Vizzini. So we're gonna get have Mike look at Box Fort Day, and I might I might get to some of the COVID test. I might. I don't want to be up here for too long.
You say that, and then it be 4 hours and 15
It
minutes
is not
later.
no because I need to get my beauty rest.
Mhm.
I mean, I'm still 30, so I gotta get my beauty rest. She said she watched it with her daughter back in the day and knew Tyra was evil. She was jealous of those young girls. Yeah, looking back on it now, but I just thought that Tyra was
Yeah, I
a
I thought
better person than she is.
and like I said, I don't know if it was like, what I'm saying, the celebrity got to her head, you know what I'm saying? Because like I said, she had the show basically made that network. You know what I'm saying? Like
Hmm.
UPN was basically
Underpaid
nothing.
Negroes channel.
Huh?
That's what UPN, the Underpaid Negroes channel.
Yeah, you know what I'm saying? Like that was a channel that, like I said, you barely remember what channel that was on, you know what I'm saying? Until
Hmm.
Top Model was on there. And then, like I said, everybody's watching. Like I said, I was watching it. So,
Hmm. Yeah. So anyway, Lisa, I would have had a What's the Business song for y'all, but I was hadn't been feeling too hot, so that's why I did not do a What's the Business. But the next time I come, I am gonna do a What's the Business. All right, so we're on Box Fort Day. Mike has not seen Box Fort Day before.
Yeah, I hadn't seen any of the stuff. All this stuff is new to me. So,
Mhm. So this is the court is getting started, Mike. We're getting started, and he got all his secret documents, and he's
that he
all
can't read.
all the sovereign citizen BS. It's all right here. He going through.
Hmm.
So let me speed this along. But look, he busy. This is the hardest job he's ever had. He reminds me in this scene um, of a student in high school that never came to class and who was always out. And the last day of class, that's when he comes to school and thinks that he's going to, in 15 minutes, be prepared for the whole semester for the final exam. That's what he's doing.
AKA Mike in organic chemistry class. That you know what I'm saying? That was me.
Well, that was me in pre-calculus. But math was never my forte. Thank you, Sissy Williamson. Hey, Janice. She's covering them in bees. Yeah, yes. Kelly G's talking about something, they were covering them in bees and stuff. That was crazy. And none of the stuff they could actually use in their portfolio. That's the crazy part. That would seem like that was the point,
Yeah.
that you would have some photos in your portfolio.
Now, I'm pretty sure there's some kind of industry logic behind that, but I'm thinking like, hell, any photo shoot is a photo shoot for your portfolio. Why would you say like, yo, you can't use these? Like, I understand like maybe some of the exotic shoots or whatever, like I said, the crazy ones or whatever, but they had just some normal ass, hey, let's take pictures. Let's take some pictures of some shits. You know what I'm saying? Them should have been in the portfolio.
Hey, Benny Ilsley. Yeah. Oh, that's nice. I wish we could see more of you. You always brighten up my day and the last. Oh, thank you. I appreciate it. All right. So let's watch this dumbass.
This morning. All rights reserved.
Oh, hold on. Let me get back.
Facts for value.
Appearing for the state of
There we
Wisconsin.
I'm here as a third party intervener in that matter, appearing as authorized representative for my client.
Oh, yes, that's right. And Duh-Rell just had his birthday on the 21st. That was the day I was supposed to come and do my stream, but I was indisposed. But his 21st was his birthday. So we're 3 years in jail on his birthday. So we got 3 years down and 1,298 to go. Bravo.
I set for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning.
All rights reserved, baby.
All rights reserved.
There you go.
All right, good morning to you as well. The record should reflect the individual known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
For the record, I don't consent to being called that name.
She looking like God. I gotta get through this. I gotta get through this.
It is noted. All right, Mr. Brooks, just preliminarily, do
so
you
tired.
anticipate calling any
Probably about
additional
got a bottle
witnesses
of
today?
gin that bitch.
I'm
right
telling you, she got some alcohol in her drawer.
there.
This is just some wine. This is a communion wine, but I need to use it because God will understand.
Yeah, nothing but the blood.
Nothing
Nothing
but
but the blood of Jesus.
I plead the blood.
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added.
Now, Mike, did it not seem to you when he was asked if do you have any more people? Did it seem like he was trying to say or imply that he didn't have anything today, but maybe on another day he would have people?
Yes,
Does that sound like to you?
That's what it sounds like to me.
Okay. That's what I
Like
make
maybe
sure
they didn't show up today, and maybe they'll be here tomorrow, and I can call them tomorrow.
I can call him tomorrow. Okay. Okay.
is your mother, Dawn Woods. So I would expect that if she's going to testify, she would
Trifling
be
whore.
here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Okay, now my ICFs is the inmate communications form. So if they need anything, they send it through. It's like an inner office mail. So he has to send it to all the people in jail, and they send it on to where it needs to go. So Duh-Rell loves to bitch and complain and piss and moan about his ICF form. So that's what he's talking about.
Oh, I haven't looked. Let me look.
He gets on everybody's nerves, y'all. He's fun to
Just
hate.
one to you and then one to the prosecution.
He's really fun to hate.
Is the audio?
It is. The audio's on.
I bet you she wears her makeup. I bet you she wears Merle Norman. The women will know what I'm talking about.
Yeah, I have no comment on that whatsoever.
When you watch Top Miles, you should know about the makeup though.
No, I ain't watching like that. I'm trying to look at all the nice looking women. I don't care about their makeup at all. At all.
Well, you need to care.
Nah. If I'm like that, I'm watching it for the wrong reasons.
Well, you know,
Do you know when those?
Saturday.
my husband, when I would look at Drag Race,
Yeah.
So that would have
you
been
know,
the
Michelle
22nd.
Visage had, big
State receive
implants.
anything through
So he'll be like, oh, there
the
go
interoffice
Michelle's
communication?
boobs.
I just checked this morning to see if there's anything new. Nothing has.
But like I said, he ain't like, oh man, her foundation is just messed up. See, if he says something like that, then I have to worry about him.
And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the.
It don't matter whatever it says. It's stupid.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state,
No objection.
from you, sir.
No objection. I definitely want those documents received as they
Hey, Trina.
obtain important information.
Look, it's very important information.
You said you forwarded them to a staff member on Saturday.
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
How the hell you don't know?
And those are 2 ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
It's a nice ASMR type thing. Very soothing. He's like, I ain't
Them
never
just
typed nothing
nails,
like that.
you know what I'm saying?
Like I ain't never typed that fast.
I remember when I was in school, I had a teacher that could type super, not only because she typed super fast, but she wouldn't have to be looking at whatever she was trying to type. So she would like be typing and then like looking over to the side, talking to you and just still typing away. And it was like the freakiest shit I've ever seen.
Tell me the topic.
All right.
We can cover it
Give
verbally.
it this foolishness.
The topic is pertaining to exculpatory evidence.
And then he just learned
Some
exculpatory.
things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make enough of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz.
Just spit it out.
Question was asked of, did he know if there were any recalls on that vehicle?
In the vehicle.
And I believe that A Brady claim should be visited because there were, in fact, recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where the Ford company were sued because, and those vehicles models from 8 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010.
All I can think of when I'm hearing him, I'm thinking of Hail Mary.
Hmm.
I'm thinking
No,
of Hail
I'm
Mary.
talking about Tupac Hail Mary.
Well, I mean, yes, but I mean, this ploy that he's doing is a Hail Mary.
Oh, it's a Hail Mary.
It's a
Okay,
Hail
yeah.
Mary.
All right, yeah. But
Run
all of
quick,
this is a Hail
see.
Mary. Like I said, this whole thing is like, man, I'm just gonna stretch this out as long as humanly possible. I don't
Hmm.
know why.
Because he didn't want to spend 1,300 years in jail.
Well, like I said, he was out. Like I don't know if we said this before or after we came online, but like, yeah, the whole thing is that he was already in jail when the trial started, right? So if
Yeah.
he was already in jail, prolonging this doesn't stop you from going back to jail. You know what I'm saying? Because you still have to go to jail once this trial is over with. Maybe
I
he
think
just
he really thought,
enjoys.
I think that he really thought, at least for a while, that he was
Mhm.
smart enough to maneuver through this.
No, cause see, well, maybe so. Cause I was about to say, like most street dudes, you know, what I'm saying I've known some street dudes in my life, and I
Uh,
know that, like, yeah, they get smart in the streets, but they realize when, you know, what I'm saying now they gonna try some stuff, but they do realize at some point when they don't have a shot, right? So, like I said, you
mhm.
know, at some point after they've tried a couple of times, they basically give up the ghost. But then again, you know, what I'm saying maybe he's not that smart as those street dudes, you know what I'm saying? 'Cause at least they're smart enough to realize, like, okay, this is a losing battle. Let me just go ahead and give up. You know.
Woo!
But
What do
yeah.
we have here now? Do you want to ride or die? La 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 la.
Yeah.
This information is very easily obtained just by pulling it up, and you will see a class action lawsuit.
Mhm.
Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and
This was covered.
in light of the fact that these vehicles were recalled,
I think it was on day 10
because of this malfunctioning throttle
is
body
when the expert testified.
for
Because they had on a black suit. I believe it was
I
black.
believe it's counts 1 through 73 to be dismissed.
You hear this? Let me rewind. Counts 1 through 73. So that is
How many counts he had? Like 77?
76.
Okay.
77 would have been the assault on Erica Patterson the day before
Mm-hmm.
the parade. Because, you know, he loved running bitches over.
Yeah.
So, yeah. So, according to him, with this Hail Mary, run quick see that he's doing, 1 through 73, that's the 6 people that died. That's all the recklessly endangering safety for all of the people he ran over. All that's going to be dismissed.
Yeah.
So then he'll have the 3 charges. And so that way he won't be in prison for a long time.
Yeah.
I
Good
believe
strategy.
it's-
Good strategy.
It's a great strategy.
counts 1 through 73 to be dismissed.
She looking
What's the
like,
response from the state attorney?
dude, come on.
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in the report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator.
Oh, he does
lights,
believe it,
none of
Benny.
them
He believes
were
wholeheartedly.
lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls.
0!
So it's a mood issue.
No recalls.
It's an issue, and I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual
God, I hate his nails.
information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is.
When the vehicles are purchased from the manufacturer, they're being sold as is. What's that have to do with anything?
I
Okay.
don't know.
They're sold as is. Okay.
Actually, like I said, no, if they're sold from the dealer or if they're sold from the manufacturer, then normally they come with some warranties and stuff. Now, if they're sold from a dealer, they'll come as is, right? Because like if you go to Ford and you buy you a new Ford, most of the time they're gonna have something on it.
Right.
You know what I'm saying? But
And
if
he
you
probably
go to,
went to a buy here, pay here.
yeah, you go to buy here, pay here, then yeah, you get what you get.
Right. Sold as is.
Mm-hmm.
There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens.
Not necessarily.
And
I had a vehicle that had many recalls.
seeing this a class action lawsuit.
Also, he trying to make it sound like he just bought that. Man, I just bought this 3 months
Right.
ago,
And it
and,
just malfunctioned.
and it just malfunctioned.
But no, you've had your mama had this for a while. Hey, Sasha. Hey, Army Lawman. Welcome, welcome. Make sure you guys smash that like button, whether you come in or out, please, and thank you.
No one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning.
Okay. Who has not been in a quote unquote class action and you get like $20 from the class action?
I got $5.13 from a class action lawsuit.
There you go. There you go.
After,
I know I got $20, $25, $15. And I'm like, oh, wonderful. Hey, Chantal and Carol Austin. Welcome, welcome. Oh, goodness, I got gas.
And
thanks for letting the world
I
know.
believe with that,
Well, it's the upward gas, not the downward gas.
Yeah, right.
like I said, the information is easily obtainable.
Easily obtainable.
I should have the information in the mailroom right
now.
That you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question. It was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir.
She's like, I'm sick of this shit.
So,
hey, Miss Santana.
Not trying to cut you off. I don't need the specifics about a class action because
it's BS.
As it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls. And more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email. It's one page with what you said. I have to turn my head. I got to figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on. Let me finish my record, okay?
All right, shut the fuck up, is what she's saying.
It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital.
It's extremely vital.
So I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do. And presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle,
It's
there
BS.
were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Mike, now she denied the request to recall the witness. So do you think this grown man, he was 40 years old here and when this occurred, do you think this grown man will take being told no
Of course.
and move
Of
on?
course he will, because he's a 40-year-old grown man with common sense. So my answer is, of course he will.
Right. Hey, JC Lay. I hope I pronounced that right. This is Box Fort Day, Janice. This is Box Fort Day. That's how we all refer to it. It's Yellow Shirt Day or Box Fort Day. you gotta be a Brooksaholics, you know. Box Fort Day.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this.
Oh.
I had no knowledge until she told me. And
But it was
that's how
easily
I came
obtained,
into
though.
the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So
I understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record.
It was just
Jay Soleil, yes. Mike is a Duh-Rell Brooks virgin. He knows nothing about this. So I wanted to get Mike's virgin responses to the foolishness.
Through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done, and you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
That's really interesting that he said that he does not have access to the internet. The day or two before this, he had a 50-minute rant about all the hardship he's having to go through because of this incident. And he mentions that he has been called, a demon and a monster on different chat rooms. So he was watching like Court TV. He named Court TV. So somehow he's reading comments from Court TV, even though he doesn't have any access to the internet.
Hey, We seen
And
the
he
Alabama
does have a
solution. We
tablet.
know that they got them phones in there. You know what I'm saying?
Mm-hmm. Mm-hmm. So, because like, how are all those people, like on Love After Lockup, how are y'all all dating and y'all are communicating on the internet?
Mr. Brooks, you're telling me your mother had that information.
No,
so
I'm
and
telling
going to
you,
trust.
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's
He's
my
like, oh
decision.
no,
I
bitch, you
object
did
to
not
that,
tell
Your
me
Honor.
no.
I understand.
I
I've made my
object to that.
decision. The decision at least
No.
says we're not going to debate it further.
Yes, we
We
are.
now have the
It needs to be-
ICF,
it
the
needs to
one
be
for the state to
addressed,
be
Your
provided
Honor.
for the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the
Mike, do you hear the tapping?
Mm-hmm.
That he getting mad. Crash out, incoming.
record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I can't
For the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact, Your Honor?
Any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
The book you won't read.
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Under what law fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
You can see the wheels turning in his head. He's like, shit, I thought this was gonna work. I thought this was gonna work. It's gonna just take the cups off.
But he just read from the script. He just going down. Okay, that one didn't work. Let me go to the next
Yep.
one. That one didn't work. Okay, let
Right.
me go down to the next one. That one didn't work.
That's it.
You're denying the legal. You're denying the motion for finding a fact. So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and
seem
I'd
like
ask that you
you're. I
stop
don't need
interrupting
your
me.
advice.
No, I have to
I need
give you
you-
advisements, sir, regarding your right to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's order.
That's funny. Zini said Bubba's making oral rulings. Oh, plenty of oral motions is going on with in the booty house.
Oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You need
Actually,
to-
I do so,
Actually,
sir.
you
That is
don't.
required by
Actually,
law.
you don't.
You need to do your job as a public servant
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go through
Honor.
these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will be
you're holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct,
She should
which
have
is
held
one
you in
of the
contempt.
options available
But
to
once
this
again, she
court
doesn't want that
under,
mistrial.
Illinois
know.
versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I
due
need you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying to have a debate.
You are
I'm merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that
I've said that multiple times. I've given you multiple
you're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner, tone
That's
of
not
voice.
true.
I
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
reform and
doesn't.
civility, and one of the
Illinois
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again, I'll
It
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras,
He is so
or
insufferable.
that you can be.
Yes, we're off the
Or
record.
that
really
you can be
is.
He's in the
okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement.
Another tacit agreement. Okay. Now the thing about Box Fort Day is they were discussing jury instructions as well.
Uh-huh.
So yeah, so Box Fort Day is an interesting day.
A wit
Hold on.
may. I have issued a written decision on that.
So
He
she's
has
giving the
not
record. I don't care about any of
thrown the
this.
headphones.
Mhm.
Okay, hold on.
And you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were
Why is
working.
my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning?
You can hear.
He's been unmuted though, for a while now. We can obviously hear him.
Headphones on for her.
I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, he is getting, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself.
How the hell do you shoot yourself in the foot by acting an ass and having them rest your case for you?
I mean, like I said, I'm pretty sure he realizes that there's no win in this case, and he's just in it for the love of the game at this point. You know what I'm saying? He's just in there for maximum irritation. You know
Yeah,
what
I
I'm saying?
mean, he's been successful.
Just to see how far he can push everything, how much can he get on people's nerves, how long can he delay these proceedings. You know what I'm saying? Like I said, he's doing it for the love of the game at this point.
Mm-hmm. But one of the people I've had a conversation with this about has said that his behavior could also stem from the fact that she would not, Don Woods did not come to court, and he has kind of resorted to elementary school logic. So, like he's upset that his mommy wouldn't come to the principal's office, and so now he's acting out.
Yeah, well, he's a man child, so what do you expect?
Yeah.
Then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited.
Oh, yeah. And so she was asking him also, if you're not calling your mom, do you want to testify? And we're going to go through the colloquy or a little mini hearing to determine that you are capable of testifying and that you are not going to run your mouth for countless amount of minutes or hours lying.
So the other 13 days hadn't proved that he's going to get on there and run his mouth and lie and everything. So they have to do something.
That's why she wants to have this. That's what she wants to have this hearing to let him know. We called the jury back in here. Mm-hmm. You are not going to be able to go into your sovereign citizen mess about oaths of offices and statement of particulars, and you're not going to misrepresent what was going on. There has to be some logic, some reality here. You can't say, that if I put butter in the microwave, then it's going to become fire.
Mm-hmm.
You know what I'm saying?
Yeah, no.
Right.
I know you got to do everything official.
Any additional witness.
Right, got to do everything official.
Yeah.
This is based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses.
So if you see him, he's looking at something, that's going to be the borrowed Bible that he has.
I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to.
Didn't you said that he threatened his mom? Didn't he pull a gun out on his mom before? I know he pulled a gun out on his nephew, but did he pull the gun out on the hey love? Yeah, do y'all know if it was did he pull a gun out on his mom too? I'm not sure.
Damn, that's some hardcore shit right there.
Yeah. See, that's the reason why he wasn't allowed in the house and he was staying in the car because he pulled a gun out on his nephew, and the nephew lived with the mama. So they be in the house and he'd have his dusty ass in the back.
And just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Burke, you're unmuted.
He's unmuted.
You're unmuted. Just speak directly to you. I'm here. Can you hear it?
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin.
You're giving him way too much information.
Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that?
There's the book.
No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that?
Oh, he might actually be
Once
reading.
again,
His head is
response
moving.
by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that?
Oh yeah, he reading.
There's no response by Mr. Brooks.
He's just looking at the
It's my
letters and they
understanding
can't
that
read.
Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol?
Well, his breath, the tartness of his breath and body odor, I think that could cause a person to be, lightheaded and
It can cause neurological damage.
Yes.
I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial?
The threats is coming later.
Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
So if you can hear me, I don't hear everything you're saying, and you know I don't hear everything you're saying, so cut the crap.
Mr. Brooks
Cut the
is
crap,
interrupted
bitch.
with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate if you would make the record clear and correct.
Make
Clearly,
it right,
he heard me
ho.
say that for him to make that distinguishing statement.
I'm sitting right
So-
here. Don't you see me looking all up to the microphone so you can hear me?
I don't have
Or
an
can
issue
hear
hearing
me
you
when
at
I'm
all,
right
sir.
here? Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell
I will
me-
ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? to answer if you have a claim against me or
I'm
don't.
going to
you
mute
wanna
him
have a
for the
claim against
moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for
was
a
the
third
secret
time
plan.
with the understanding
Disrupt.
that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no, and that he is not going to testify. So once again, I am unmuting him.
Oh,
Sir,
hell, what I do?
have you made a
Okay.
decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted? 'Cause you just
Sir, do you want to testify in
just
this
said
case?
you was muting me when I had the headphones on just a minute ago. You just said you was muting. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one
Yes,
last
yes.
time. Do
didn't
you
ask
want
me
to...
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer.
me.
I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to
Very well.
willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum, again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom because this morning alone, he has yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings. The court,
Hey,
the public,
Aaron.
the jurors, the public. Absent adherence
Hey,
to these simple
QTC.
rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on valence, this court will find that he's forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct.
What type of stupidity is this? Why would
I mean,
you
she's
do
trying
this?
to give him every chance in the world
No, I'm not talking about her. I'm talking about
well,
him.
because he's an idiot. So, yeah.
I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, Do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking. I don't.
He is willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying.
Did you hear me say that?
Answer questions for. I didn't hear you ask me anything.
Sir, stop talking and I'll ask it again. Sir.
Can you ask me to stop talking
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time. All right, then let's. Once again, Mr. Brooks is being disrespectful. He is blurting out information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its me of practicing law without a license. Again, all attempts to deflect away. I'm going to mute him once again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify. And that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back, again, to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony,
back with the Bible,
and looking at the balancing test that this court must consider.
Hold on, let me speak this alone.
This court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced.
As you can see, why I'm speeding it up, speeding it up.
State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony,
yes, you just got to go through the legal
right to testify
mumbo jumbo.
Previous to that, be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days.
Once
of trial.
again,
So Mr. Brooks has
she trying to make sure that this thing does not go to a mistrial.
He has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, where in that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process.
Look at
For
him,
example,
demon horns on his
presentation of
head.
evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture, and ultimately went on to conclude the following. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where
I'm telling you, she
incompatible with
is
the assertion of
thorough.
the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this
He got
trial,
some
and
secret
specifically
documents
today,
he
based upon his failure
reading.
to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken by this court really as no, meaning the specific question, have you made a decision? And it's for all of those reasons that this court will make a finding he has forfeited his right to testify.
He forfeited his right to testify in his own defense.
Well, he
In
wasn't
his
gonna do
own
that
defense.
anyway.
True.
Cause
I'm pretty sure that he did not want Opera asking him any questions.
yeah, because they was gonna light him up on cross.
And I was hoping that he was arrogant enough to actually go through with it.
I guess,
I
like I
was-
say, he's not that dumb. You know what I'm saying? He might be dumb, but at least there's a limit to his dumbness.
I mean, it's pretty dumb.
Yeah. So even he's not dumb enough to get on the stand. So I got to give him credit for that.
I think that he would. No, he wouldn't have. He wouldn't have.
With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask they honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir, you
You're trying to, you asked me a question.
no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me. You can't do that. You're violating my constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities.
So she's offering to give him yet another attempt. If you go through this with me, then you can testify. Dumb.
To do, and you have decided not to.
No, you can't tell me what I decided to do because I didn't decide to do or not do anything.
Are you
By
willing
law,
to?
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Do you recall what was going on Friday?
Mr. Brooks, I'm going to mute him.
He's acting a
Again,
fool.
I'm not going to have a debate. I've made a finding. I've given him yet another opportunity.
See?
If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom, and that
Hey,
his
Funds
appearance
Court.
from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
Like, how could you, how do you do this? And like the jury is not stupid. They know if you've been moved to a different courtroom, this is what you've been doing the entire time, then you was acting a whole fool.
But I mean, also as a jury, they seen how he's acted when they were actually in there as well, you know? So like I said, they could just imagine what the stuff that they didn't see.
And then while he's over there fussing at the bailiff or whomever, he's wasting his time. Like, how could you not be respectful to the people who has your life in their hands? 1,300 years. And of course, he's a victim. You males, y'all are some of God's most ridiculous creatures. I blame this on men's.
No. See, if it wasn't for the women he was trying to run over, he wouldn't be trying to run over people. Like I said, no, I'm gonna say this is the women's fault.
Oh, the women's fault.
If it wasn't for the woman, he wouldn't be running over the women, and we wouldn't be in this situation.
I will say if it wasn't for his mother enabling him, he wouldn't have been in this situation.
See, that's what I'm saying. It's
But his low down dirty dog of a daddy went there.
Please be seated.
So this is his fault too.
Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner.
Yes, Jason Statham.
At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon.
Come on, victim, what's wrong?
I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. They'll get them back to you during deliberation.
Oh. Look at him. Dumb bitch.
Looking like an idiot.
Oh yeah, he the police. He look like the police too. If I saw him, I'd be like, okay, you're military or you're the police. One of the two.
Before we begin, I will have Teresa print off what at least we do have for both parties.
Okay, we can skip
I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over during the last session.
All right.
For the record should reflect that Mr. Brooks continues to appear
Munchkin.
from the other courtroom.
Let me bring up Munchkin so y'all can see him. Shut up, Michael. Munchkin, come here. Don't roll over on your back and rub your tummy. Come here.
See, that's what I'm talking about.
I'm too old.
The dog ain't right.
Oh my goodness. Here. Hey everybody. I just got groomed and I'm clean. And he got his little shirt. Says that the snuggle is real. No. Oh, it's here for the cuddles. It's here for the cuddles. Hey, Uncle Mike. Hey, Uncle Mike. I love you.
Yeah, whatever.
But they go guitar to some demon dog.
Mm-hmm.
There you go, Mike. All right.
Like I said, me and her on the same page.
Y'all gonna quit talking about my baby.
Nope.
She said dog or Chucky. Well, y'all gonna get off Paisley. Off my little gremlin. My York. Oh, okay. Hopefully, if anybody wants a spoiled Shih Tzu, I'll mail them to you. All right. Let's continue.
I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand. And I just want to make a full record of, he did a...
So Judge Duh-Rell is doing her, I call this like the 50 Cent level of petty. And so like he's over there in the other courtroom telling me I can't hear and y'all got me muted, I can't hear. So she's bringing up the person, one of the tech people who's in the room with him, be like, yeah, it's loud and we can hear.
Yeah.
There's no problem
she's doing
here.
everything she can. She's
Mhm.
doing everything she can.
Decibel reading regarding the audio as well. All right, we have Deputy Kibler. If you could take the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that.
So it's loud in
Did you have
there.
any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
Look at him. Just a clown.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
Thank you.
Oh,
Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy? All right, thank you. You may
oh,
step down.
you shouldn't give up so easily.
All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have, I have it up on my screen. Can you do a, project it, please?
Can I just share it? Is that if I share the clerk screen?
Yes. All right. There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to do shall be the truth, the whole truth, and nothing but the truth? All right, thank you.
This is an IT person, if I ever seen one. He got on the IT polo. I guarantee he's got on khaki pants.
Seated. State your first and last name for the record, please.
Zachary Trebain, Z-A-C-H-A-R-Y. Trebain is T-R-E-M-A-I-N-E.
All right, and what is your position with the Clerk of Court's office here in Waukesha?
I'm the IT coordinator for Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DB meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen into the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom. And that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
A little bit.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65, so it's louder than the audio feed going to the media right now.
All right, thank you. Any question from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, it appears the time's either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
okay.
It is approximately 9:26 when the photo was taken.
Oh, those were my questions.
All right, thank you, Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay. Thank you.
Okay.
Mr. Brooks, any questions for this witness?
Yeah, for the record, I don't consent to being called that name.
Still shenanigans.
Do you know anything about the hearing when someone has hearing loss in any of their ears?
I do not.
He's not a doctor, dude.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
You wouldn't understand it anyway.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up.
He looks so defeated.
I would think that he would get tired of this at some point, you know? At some point, I just like, look, I know I done lost, you know what I'm saying? And I know I've been bullshitting this whole time, but you know what? I think I'm just ready to go back to the cell and take me a nap.
A narcissist does not concede defeat. He looked like, why am I even here?
Sure.
You are in the meeting now.
She done pulled you into a Zoom
I need
meeting.
to get the other courtroom in, so just one moment.
He looked like those two brain cells he has is fighting.
Okay, hold on, please.
They
And
fighting
they're
each
both
other.
losing.
They both lost.
Stop the call for Polycom to Polycom, and then I'm going to call it into the Zoom so I can share the screen with the exhibit. Left to help read your instructions. Copy that.
So are you calling again?
Yep.
Okay, good.
All right, so now they zoom into the other room so he can see the exhibit. It's not an exhibit, it's a exhibit.
Oh,
He's like, I got all the exhibits. Look at him. Like he's been lobotomized. He probably should have already been lobotomized though.
You are in the meeting now.
That's what I'm saying. Like he looking like, man, I'm tired of this. Even I'm
I've
tired
now
of
changed the
this.
audio visual from the Polycom unit to the use of Zoom. I called in both courtrooms, and they can hear from over there. And then I'll do. I just need to get back on so I can get the email. Give me a second. I have to go from double screen to single screen the way I sign in, but that'll take me just a second, and then I'll share screen so the color exhibit can be viewed by the defendant.
Look at him. But there's some synapses not firing. He's like, what can I do?
All right, now the court is sharing screen, and the image is being displayed.
Oh, I'm freezing. Come on, Zibbits.
You see it? Okay, thank you. Any questions regarding that then, sir?
Yeah.
My question was, pretty much already answered. You don't know if me myself can hear everything you do in the courtroom, correct?
I do not, correct.
Come on.
Okay.
Okay, thank you, sir. I'll stop sharing.
No further questions.
Okay, thank you, Zach. You can step down.
That was a waste of time. I'm trying to get to when the fork comes out.
I said I have numerous documents.
Okay, hold on.
Thank you, Zach. You can...
All right. He looks stupid, not bored. This is a look of stupidity at its finest.
All right, now the court is sharing screen, and the image is being displayed.
Yeah, I see it.
You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything you do in the courtroom, correct?
I do not, correct.
Okay.
Okay, thank you, sir.
Such a
I'll
waste
stop
of time.
sharing. Jury instructions, they were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same, 107 pages, and then my written copy is on its way.
I assess the value, return the value of each document. That's if I'm not muted.
You're not muted.
I also would like to again ask for subject matter jurisdiction to be proven on the record.
Your request is denied.
It has yet to be verified. It has yet to be verified.
Your request is noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence?
Because the evidentiary phase is closed because you fucked yourself in the ass. That's why.
I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record
He's such
for
a
evidence.
child.
How's that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony. when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
Uh-oh.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm denying your request. I said.
So you're saying that I have. So you're saying that I.
Do you know what evidence he's trying to put in that he hand wrote?
Yes, the ICFs, stuff about her record, the statement of particulars, all the sovereign citizen stuff.
Oh, okay. All
right. So nothing.
Yeah, nothing.
Mm-hmm.
Evidence and to have exhibits as the state's been able to do.
Mr. Brooks, I'm not going to have a debate about this now. I got to mute him once again. So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings.
He is mad, baby. Look at that face.
One, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe, without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Muted.
All right, you're unmuted now, but you have to not interrupt.
No, you can't. I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them. You filed everything that I gave to you. You
right,
filed.
Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor.
Oh, Lord.
I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law. And you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice.
It's your
choice. If he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right, I'll mute him once again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to pick up the documents from the floor and put them in front of him.
And I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on a defense. How can you tell me when I done stated
I'm going to mute it once again because again I understand.
Look at this shit in the garbage can.
And he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf.
She looks so studious. Like a little naughty librarian.
I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the
I know y'all like
from the
naughty librarians.
From the amended information on count.
Once again, it's one of those things like, what don't I like?
70.
Okay, here we go. It's time for the fort.
No, I want to I changed, hold on. 76. The 76 count. Just want to make. It says near Frame Park, so it is in there. But that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107.
I wonder how long is it going to take for her to realize what he's doing.
Just a few minutes.
Fair enough. There's 107 pages. I certainly can give the parties some time.
Because like I say, right now, she's all in her business.
There you go.
Mm-hmm.
So there you go. He's nice and safe and protected behind the fort. Oh boy, box sport day, man.
You gotta adjust the fort.
That's insane. A box fort. Like if you watch his live and read the comments.
Mr. Brooks is requesting to go back to his cell at this point. I'm going to deny that request.
I'm trying to leave, go back
in the other courtroom.
Back to his cell. Look at him peeking from around the fort. Look, he adjusting the fort more.
Got to tighten that fort up.
I can't let none of this get in. He bobbing him down like he rapping. He probably rapping one of his god-awful rap songs. So let me speak this up a little bit. Look at him. He having a good time. He going off.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. Can't decipher what he's yelling.
That's too fast.
Well, ain't nothing going on, so.
True. We went in his little secret document folder. Oh, he upset.
Yeah, what is he? What is that about? Is he fussing at the bailiff or something?
Well, he's mad about what's going on in court.
Well,
So the bailiff's the only person he can talk to.
Yeah, but he like doing all this stuff.
That would require him to have a call with me.
Now you'll be able to actually hear him yelling soon. So you could hear him yelling from the other courtroom, and it wasn't like on the feed. Like you can literally hear him yelling. You mean
like from one room to the other room? You can hear him?
Yes. You don't know what he's saying, but you hear. You hear that. She look like, Lord, let me try and get these juries so I can get this over with.
Mr. Brooks, I know you're still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
Oh, he's slamming his notebook down, slamming his papers down. I wish I could see his face. I wish I could see it. I could hear what he was saying too. Okay, I'm trying to speed this up a little bit further.
Mr. Brooks, if you have specific instructions or categories of instructions that you...
Is he muted? That's why we can't hear him? What you doing?
I didn't do anything.
Man, pressing all them buttons all
I didn't
the time.
press any buttons. I didn't press any buttons.
I gotta press all the buttons.
You're being mean to me.
You believe this court...
What were you asking me?
Oh, because like I said, it looked like he's it looks like he's fussing at somebody, but I guess they must have him muted or something. So that's why we
muted in the courtroom because he keeps running off at the mouth. So he was fussing at whomever is in the room with him.
Yeah, it just looked weird because, like I said, it looks like he's fussing and yelling, but like I said, ain't no sounds coming out, so he just looks even more crazy than he already is.
Consider, I need you to write them down on a piece of paper.
I didn't realize he was doing all of this.
If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated, in a loud, raised voice, I'd ask that you write it down.
She's gonna tell them to move the boxes soon. See, this is a lot of dead air.
Yeah.
On box fort day.
But like I said, he looks animated though, so something's going down in there.
Oh, something going down. Oh, he didn't took the jacket off. Oh yeah, he is upset. I like her ring though.
The judges.
Mm-hmm. Even though I would say that the ring is basic because of regular stone is boring to me.
Some people like the classics.
I understand. I was gonna be just like Princess Di. Don't give me no diamond. Give me a sapphire. Ruby. I'll take it. Super Killer G said, "All comes to Jack and it's on now." Look at him. He is. I didn't realize he was clowning like this behind the boxes.
Yeah, because like I said, he's going off whatever's happening. It is going down in that courtroom.
Mm-hmm. You can tell it's serious because you can see his forehead, and he has a lot of emotions he expresses in his forehead.
Or maybe it's because we're playing it at 3 times speed.
No.
Maybe it just seems that way. Maybe he's just all nice and calm and everything, but at 3 times the speed, it looks like it's going down.
He is not nice and calm. QTC says every time he gets real angry, he starts shedding clothes for some reason. Sierra says his breath stink. Now, you're right, Sierra. His breath, you know it's bad. His breath, and I bet you, I don't know what kind of deodorant they use in jail. It might be Tussie. But it's not a good deodorant.
Are there any specific requests for either instructions
That's
or
more
categories
grandma stuff
instructions
right there,
that you want
baby.
this
Ooh, I ain't seen that in decades.
Please write a note to pass to the bailiffs who can let me know.
He over here fidgeting.
Do they even make that still?
What?
Tussie.
Yes!
Okay.
They still make Tussie. You can get it at Dollar General and Dollar Store Tree. One of them places.
Like I said.
Save Mart. You can get all the Tussie you want. You even got the one in the little jar.
See, that's what I remember. You know what I'm saying? My grandma and them had.
Tussie in the jar.
Bring it back, memories.
Hey, Intimidator 39. Welcome, welcome. He said he was like a dog barking over the fence. It's like PJ, I'm not PJ, Paisley trying to bark over his crate. Like I said, it's a lot of dead air.
Yeah.
That's why I really don't like to play box fort too much.
Yeah. Well, I mean, like all court cases are like this, you know what I'm saying? You know, you see like Law and Order and stuff on TV, you think that like, oh yeah, court cases is like, you know what I'm saying, a lot of action. Like, no, you actually go to a court case and it's like, yo, this is what a court case is like.
All right. Oh, there you go, moving the box fort. Hold on.
As it relates to the jury instructions, sir. I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, so I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see
Move the fort.
Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third one. Mr. Brooks, I'm going to ask you for a third time to have any requests as it relates to the jury instructions, any requests for instructions that aren't included that you believe should be included, any edits or deletions from the packet that has been provided to you.
Hey, Vicky.
Hey, why do you tell them to move my body?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Do you have any requests
First of all,
related to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any requests?
I'm tired of my race being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated.
Nobody gives a fuck why you're frustrated.
And make decisions based on what you think I said when I didn't give consent for you to do any such thing.
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing.
You can see
You don't understand anything, Your Honor.
he got little veins in his forehead popping.
You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks.
Bitch.
Do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks. I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I asked for my boxes to be moved.
That's right.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break them.
Yeah, I'm still agitated. I ain't gonna stop being agitated.
Won't stop, can't stop.
That ain't gonna stop. You sit up here and do everything you doing and think God don't see what you do.
Oh Lord, bring God into it.
You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
Yeah, I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little sir. Now it's all this sir and all this. I'm gonna get where I'm going.
Yeah, you're gonna get there. 1,300 years.
Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
If you don't take that
I
diaper
need
off
to
of his
know what your
face.
position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with?
Stupid.
You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb.
Oh, life and limb.
Twice. I'm already charged with the same count in Milwaukee. This for the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted.
Absolutely, QTC. This is exactly how he talks to his girlfriends. This is exactly, and you can tell not respect women, which seems to be a theme now going on in the world. But he does not respect women at all. And so all of this yelling and lunging at the computer screen, he is trying to exert control over her and Opera, of course. And it's not working. And so he's getting more and more frustrated because he has been controlling the whole show anyway. So now you didn't talk yourself out of testifying and giving a close. I mean, you just screwed yourself up. So this is all he can do is just act the freaking ass.
But the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
No, I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're going to charge you.
It's a different date of violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
So basically, he's being charged for attacking Erica the day before the parade. That's the bail jumping, because he was already in custody from Milwaukee, and then he got out. He did the exact same thing in Waukesha.
Mm-hmm.
So it's 2 different charges.
Yeah.
Dumbass.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute that refers to the double?
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have, sir?
Don't talk over me. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you.
Because y'all are both equal.
Mr. Brooks, what other requests do you have?
And I just asked you not to talk over me.
Bitch, you better get it together.
You've been making no record the whole time you've been over there. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing.
Oh, you let her.
No matter how egregious and biased it is, I let you do what you was doing. Because we both know that what you're doing is not right.
I disagree.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent.
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he hasn't understood. All right, I've made a note of that. What's the next issue?
Bail jumping needs to be dismissed.
Do you
Okay, hold on.
Their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity because you haven't gave me an opportunity to properly defend myself and put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me we wasn't in the evidentiary phase.
Y'all weren't at that time.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes. That first count 74 bail jumping needs to be dismissed. You can't charge me with 2 things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one company gonna charge me with it or y'all, but it can't be both. It's the same. It's pursuant to the same exact thing that I was on bail for. The same exact thing. The same exact case. So why are we giving the jury instructions on 2 cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is going to be found a reason for it not to be valid. What are we doing here?
Mr. Brooks.
What are we doing here?
Why should I be here when
I made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talking big game to save yourself enough space. But everything I put up that has no merit in your court. None.
All right, I've asked him many, many, many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Oh, he's like, I'm so frustrated.
Sure, I'm sorry. 154 summary of evidence.
Let me speak this along.
I believe we had a map, actually 2 maps that summarize the. We had 3 maps. I think the one was summarized his route, the path they took. The other one summarized the victims who were struck in specific locations, and the other one summarized the positions of the law enforcement officers at the various intersections throughout the route.
Oh, you got the box fort back. The fort coming back.
All right, so let me go through the list from the state.
There you go.
Turning to page 61.
I just remember he's chained to the floor, so he couldn't just get up. He had to sit there and try and.
So I consider the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury.
He's like, okay, I'll slide over a little bit to the side so she'll still be able to see me, but I still have my fort ready.
To review the evidence and make a determination as to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the 3rd count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's another request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65.
Look at it.
The state is asking that I simply instruct the jury based on the pattern instruction. The second paragraph, I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom, this must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you requested to be taken out? That's fine. Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see
there
them.
we
He
go.
can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there. I'm not putting them there. You can't see me. I'm putting them there for a reason.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's
Well,
choosing
the accusers are dead. You killed them, so those are your accusers.
to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner.
When they take the fork the next time, that's when I'll stop it.
Inclusion
Don't get my
of
wrist.
the instructions
Now,
that
how
were
many
put
times
on
did
the
he
last
make the
couple
fork?
He makes it, I think, twice. So it's gonna get snatched away again.
Oh, okay.
I just
You
don't
mean
know
3?
where.
Because that's already the second time. So there's what, 2 more or?
I think this is the third. This is the third time.
Mm-hmm.
Okay. So you see, there's a lot of deadness.
Mm-hmm.
Okay. Let's see.
Nothing I say even matters.
Hey, Tony.
So what's the point of me being responsible? You can't make decisions for me.
Mr. Brooks, I'm going to mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me. I haven't been able
Mr.
to
Brooks,
present
I'm going to
evidence.
mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment.
Oh, I know he stinks so bad.
And then I've reviewed 154. I believe that's appropriate.
I bet you smell like ass, funk.
I'm going to pull it up
Jail.
just as a draft. I'm not sure if there's anything that needs to be.
Have you ever smelled someone that's been in jail?
No, not necessarily. Because like I say, I try and stay away from jails as much as possible. Even though I sometimes have to work in there, but I don't go to where the prisoners to be at. So, nah.
Well, when I did probation, I used to have to go to the jail docket, and this is one particular day. I don't know what was going on, but jail has a distinct odor, and you could smell that baths have not been taken, and they have not brushed their teeth in quite a while. So I'm just like, my eyes was watering so badly, and I'm just like, what in the hell is going on? Like, why do they all smell like this?
Yeah.
And some of the bailiffs, they were, like, Miracle, you want to go back there? We can get you one of them little orange jumpsuits. And so I said, so if going and getting arrested, do you get a new jumpsuit, or do you get just whatever one they hand to you? They're like, whatever one we hand to you.
Yeah.
I said, so what about the little shoes, little crazy people shoes? He's like, yeah, you may get a new one, you may not. It just depends. You just gonna get whatever we give you. I'm like, oh no. Oh no.
So yeah, like I said, that was my goal in life, is to not end up in jail. Like I said, the closest I've gotten, like I said, since I had to work there, the closest I've gotten to like actually getting in there is just the intake area. I hadn't gotten any further than that. So, and I choose not to go any further than that.
Did I tell you about the dude? You remember I used to work at the Alabama Clinical School, which was the place with the juvenile sex offenders.
Yeah.
It was like a hospital / jail, but not really jail. Remember, I don't know if I know I've told you, there was this one kid that his parents actually paid for him to be there. And so he had a habit of whipping his uhu out and doing what he wants to do in the class. So one of the kids was making fun of him, and he was complaining to me about it. He said, do you know that those people wrote Master B on my door? Like Master P, Master B. I couldn't even hold it in. I laughed so hard when he said that. I was like,
So
I'm
he
so
just
sorry.
in the middle
Yeah,
with everybody there, just
whip it
whip it
out.
on out.
Yep, whip it out.
What? How? If he ain't got enough shame for that, why is he all shameful that they making fun of him? You know
Well,
what I'm
I
saying?
mean, they were
No.
all kind of crazy. I had one who was a Chester molester.
Uh
He
huh.
was one of the older ones. He was like 18. And so
Mm-hmm.
he told me he was in love with me and that he
Oh.
wanted to marry me.
Oh.
But you just got put on punishment because you and another dude were the story was that we'll just say that the one dude's name is Michael, and then the other dude is Andre. Uh,
Mm-hmm.
Michael was allegedly was praying, and then
Mm-hmm.
Andre came behind him while they were praying,
Uh huh.
and things occurred.
And things occur.
And things
Uh huh.
occurred. hmm Things occurred. And what was crazy was the one who was in love with me.
Mm-hmm.
He had really dirty fingernails,
As
like
they tend to have.
super dirty. Like there's more than dirt there.
Uh huh.
Dirty. Uh huh.
Ugh.
Uh huh. Uh huh.
Mm-hmm.
So anyway, I'm sorry, y'all. I have to give y'all some backstory on my crazy life and the crazy people that I have met.
Mm.
Oh, I remember this one dude that I was talking to was telling me about a girl that he knew who got arrested and was put into the padded cell, took off her menstrual napkin and wrote in blood on the wall.
That's just being nasty right there.
But what's funny is this was long before I started working and doing probation. But I
Mm-hmm.
was telling the people in the jail that he said, "Oh, I was here when that happened." He said, "You want to see what the padded cell looked like?" I'm like, "Okay, you can take me to see it." It's a green room, and it's a slot on the wall, and
Yeah.
so for them to look into the slope. So I looked and I said, so they strip you naked and in here. I'm like, yeah, they strip you naked and you be in here. And he
Mm-hmm.
said, "You see those little slats on the floor? Guess what that is?" I said, I know that's not to use the bathroom. Yeah, that's to use the bathroom. A vent on the floor,
uh,
butt naked, vent on the floor. I said, so what if a woman is having her menses? Like,
mm-hmm.
she gonna be in that room
Mm-hmm.
with the naked with the thing on the floor. I'm like,
Mm,
God
mm,
dog.
mm.
He said, so look, when people come to jail and they ask, "Are you suicidal?" You say yes. They're gonna continue on with their questioning, and then as soon as they're finished, they're gonna strip your clothes off and put you in the padded cell.
Oh, okay.
He said,
Yeah.
because we don't diagnose mental health here. So if you say you're
Uh-huh.
suicidal, we gotta take it seriously. So you're going in the padded cell. I like, God dog. I'm good. It's
Mm.
good to know these things.
Yeah, see, like I said, my life goal was never go to jail. And like I said, not even just to be like, oh yeah, I got to do stuff at the jail. Like, nah.
My dad said, he said, if you get arrested one time, I'll bail you out one time. The second
Mm-hmm.
time, you in there. And I'm like,
Well, I
that
told
ain't
my daughter if she ever went to jail, I'm bail her out, but she gonna sit there for about 24 hours before I do.
uh-huh.
Make
But
her think
anyway,
about what she done did.
right.
Dance team.
So, controls, you should rely on the chart only to the extent that
Look at him.
typically where that comes in
Bitch is
is
mad.
for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's
You, and I think that was
ask him if he has any position regarding any of these last issues that we've discussed with as it relates to the jury instructions. Anything from you, sir, on the jury instructions?
This is brilliant. plan?
He's not responding to the question.
Booty bandit, yes.
Yeah, we can do this the
I
hard
believe
way.
that covers
or the
all of
easy
the
way.
issues
But
that
the
were
choice
raised by
is
the
yours.
partisan. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean you giving me one final thing? I didn't consent to nothing that y'all been talking about. And I say y'all because I haven't been participating in none of that.
I understand, sir. Your objections noted. Your lack of consent is noted.
Okay, I don't see what's going on in there. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
even during this time, though, you've been incredibly disruptive. At one point you were muted for an extended period of time and you were yelling so loud, sir. We could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how can you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it. You can't just say, I'm going to do this because...
Sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You're the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again.
All right.
She has been working on the verdict.
Yeah. All right, so you have to come back in the courtroom.
Yeah. So is he gonna build the fort in the court, in this courtroom?
Did it get taken back out? Maybe that was the last fort. No, he goes back. I'm trying to remember. Y'all tell me, whoever was here, does he get the fort taken away again, or was the one that we saw the was it for the fort? Look at it. I know you are itching and scratching. I'm trying to speed this along. Playback speed. Let's try it. Okay. There we go. That was the last one? Okay, thank you, Sierra.
All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the I understand your objections
I don't
noted.
want to be in this courtroom.
If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
So you don't address subject matter jurisdiction for the record? Or are you going to state it on the record?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to state
objection
it
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't
the
have.
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
Here's my question. How do you not understand when you asked to do this?
Right. You know.
This is what you asked for.
Mm-hmm.
So now you don't understand? Okay.
Mm-hmm.
That's your choice, sir.
May I please go back into the other courtroom?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you've
So I
asked,
didn't-
but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
But based upon what conduct? Me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm making
engage in a colloquy regarding your right to be present in a
Okay,
knowing
thank you,
and
Tony.
intelligent and voluntary?
So that was the only box for it action.
Mm-hmm.
He asked. Y'all so funny.
waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom.
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand. I'm not making a voluntary waivery of anything.
A waivery.
Are you willing to rephrase that? If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive
Please.
behavior?
I do not understand the questions that you are asking.
We'll answer the questions directly. For now, he is to remain in this courtroom.
Oh.
I'm requesting to not be in this courtroom.
But you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
All right, let me start with the jury instruction.
You'll start
There
with,
is one I would
start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not going to address
Under
that
what
further.
law? Under what lawful law?
Sir, please do not interrupt me again with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me because I don't understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that right?
anything. Nope. I don't understand. Nope.
Then you're going to stay here for now.
And under what lawful law? You can't force me to stay somewhere that I'm making a request not to. You can't make me understand. You can't force me to understand what I don't understand. You can't force.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present without disrupting the courtroom, as you say that I do, and over talking you, as you state that I do. I'm making a request merely to not be present for these proceedings.
You notice he keeps lunging at her when he's talking to her.
Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks.
Victim.
You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
What's crazy is he has been a member of the inmate population for a very long time.
Yep.
A very long time. I'm talking about since I was in high school. He was committing crime. So that's a long time ago. So you understand what's going on, bitch. You understand.
Yeah.
You're, in your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify and your right not to testify. And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify on your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct.
I understand you
because I never consented to it and I never answered something.
I understand.
And I just stated the reason why I didn't answer because I don't understand. You cannot force me to understand what you're asking me.
Sir, I could not even get through the advisement. You wouldn't even.
Yeah, that was your phone, wasn't it?
Yeah.
Oh.
Listen,
you need to get it?
Talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning. With
an adequate audio and visual system connecting the two courtrooms.
Your
functional equivalent
to your equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen. You always state that. But it never refers to a fourth option that you refer to. It never refers to.
I'm not going to debate this with you. If you continue to bring up subject matter jurisdiction, Illinois versus Allen,
I didn't bring up subject matter jurisdiction.
That I made earlier,
I'm trying to figure out why I'm being held in contempt.
Frustrating the purposes of this hearing.
I'm trying to figure out why I'm being held in contempt.
Which is to finalize the jury instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt.
I never held you in contempt, sir.
You attempted to.
Nope.
You've never attempted to hold me in contempt.
No!
I'm not going to revisit all of these issues.
When I asked you where you hold me in contempt, you said civil.
Are you going to respect the decisions that I've made?
They're not
interrupting
They're
me?
not correct decisions, Your Honor.
I understand that.
I can't answer. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
advising you
arguing
that
with
if
you
you
about what
continue
you ruled.
to talk
I'm saying,
over
how
me,
can you do that without my consent?
If you continue to raise issues that I've already
That's a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
Absent you, I know you've requested to be there.
I made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still.
also won't have a dialogue with me about your
Because
understanding.
it's my Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't force me to do anything, actually.
No, you're right, but I can make certain findings that you forfeit rights that you have based upon your
based
conduct.
on what lawful law, Your Honor?
I've cited the law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am moving
That I can
on.
be present from another courtroom.
I need
if I
to
forfeit
discuss
my right.
instruction 315.
Look, her hair is even.
I don't
Language
understand.
needs to be modified based upon the court's earlier ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Mr. Brooks, I completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely uncooperative with court this morning.
That's because I didn't understand. I'm explaining why, Your Honor. I'm not trying to leave it where it was at. I'm attempting to
answer the question.
That's right, Mike. Don't leave it where it was at.
attempting to
So I'm going to go
explain myself.
Hey,
of
Carly,
why I did
Cammie,
not
welcome,
answer.
welcome.
It was because the way that you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to instruction.
Nobody
315.
cares.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
if I'm telling
do
you
you
I don't
understand that I'm asking you to be
No,
quiet?
I don't. No, I
Mr.
don't.
Brooks, please stop
And
interrupting
for the
me.
record, I don't consent to being called that name, Your
You
Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement. So I
Hearing
know
and
you can hear
understanding
me.
is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're gonna at some point you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that.
I will
He's a master gaslighter.
explain why I'm bringing up instruction 315.
And I'm not gonna understand your explanation.
Well, you can't say that if you haven't heard what I have to say.
Didn't you try to do this earlier before lunch?
But I need to clarify something, because 315, which is the instruction that has it's titled Defendant Elects Not to Testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There has been no request made. And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
All right. Mr. Brooks, do you have any position on whether this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's entitled Defendant Elects Not to Testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by a defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way, and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand.
The
what
jury
you're asking.
instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My question to
never say
you
yes or no.
is,
I never
do
say
you
yes or
want
no.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because
given
I don't.
this instruction.
I don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
Oh, please.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying.
So she's doing everything that she can before the jury comes back to try and put a Band-Aid or, tape some paper over this turd because it's a mess.
Yeah.
It's a mess.
It really is.
Should not be considered by the jury in any way and must not influence their verdict in any manner.
We got more minutes and then we're going to call it.
Making such a request for a modified instruction.
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I really do. But in light of the court's decision that you forfeited your right to testify,
how did I forfeit something I never said?
Do you want the jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based upon there has not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
all caps,
what we call the sentence capitalization for the charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that I mean...
And I can guarantee you that they got the not guilty and the guilty verdict forms. Those not guilty got pushed right over to the side. And that foreman said, give me the pen. And we're just going to just get all of the verdict forms, the guilty.
Yeah.
And it took them as long as it took to, like sign those verdict forms, is how quick they came back. It was that fast.
Yep. I believe it. Because like I said, I know if I was on this jury, I would have done the exact same thing.
Yeah, I mean, you couldn't have been able to tell me anything about. Well,
Mm-mm.
maybe ain't no maybe. There's a
Mm-mm.
picture of him in the parade running somebody over. It's on
And once
camera.
again, because like I said, the other thing is that like the jury knows. I mean, first of all, they see how you acted in court, but like I said, the fact that they have to send you out for like extended periods of times, like
Hmm.
you know that there's just foolishness going on in that
Lots of
courtroom.
foolishness.
And so, like I said, yeah, I'm like, man, let's lock him up, lock him up
Forever. Well, I mean,
forever.
technically he is locked up forever. Okay, well, it is. My time has ended, so we're gonna come back. Probably, I may try to do another stream this week, but realistically, it'll probably be next week, and we can
Hmm.
finish box fort day. It's not that much left. We
Yeah,
can finish box fort day, and then I want to show you the COVID test
yeah.
because the COVID test is pretty comical too.
And once again, I want to go back to something I said at the beginning of the stream. Is that like, yeah, Miracle was like, oh, we're not gonna be on here long because I'm not feeling well and I'm tired and this, that, and the other. And I said, yeah, you say that, and then we're gonna have a big long marathon stream, and look how long the stream has been going on.
This is not a marathon stream for me.
This is a marathon stream.
I have back in the day. I used to pull a shift. I used to be on for
No, I
like
do
8 hours.
know that. I do know that. I remember waking up at like 3 o'clock in the morning and you're still streaming. It's
I
like,
was
girl, take
rolling.
your butt to sleep. You
I
know
was
what I'm saying?
rolling. I got me a glass of. I got my Fundi wine. I drank the
Mm-hmm.
whole bottle of wine. I was having a
Mm-hmm.
good time. Now my behind. I have when I go to karaoke. Have you seen my karaoke videos?
I've seen a couple of them. They come up on my little
Well,
thing.
good, good. So my karaoke
Mm-hmm.
videos. I mean, karaoke. I can drink. I can't drink alcohol anymore. I was already a lightweight before. I'm really a lightweight now. So I'll drink one glass of wine. I don't even get any good feels from it. It's just I'm drinking just to drink.
Mm-hmm.
Before I leave and
Yeah.
or on the way home, I get really congested. I can't breathe. I have this tightness in my throat.
Mm.
And when I finally get to the house, I don't know if when I'm brushing my teeth, I hit a reflex back there,
Mm-hmm.
but
Yeah.
I've been doing some projectile. Like I
Yes.
got to rush I got to rush before.
Well, you know what you have to do, right? You have to build up your tolerance. So we can I'm come over there and we gonna build that tolerance up. You know what I'm
I
saying?
can't fool with you, Mister. What do you drink? Wood something bourbon. What do
uh
you
Woodford Reserve
Woodford
and some
Reserve?
Maker's Mark. Those are my
Mark.
two drinks of
Mm.
choice.
He'll come with a bottle this size, and it'll be a brand new bottle. He'll drink it. He may leave this much left, but the bottle will be gone. Mike just.
Yeah, I come over there with like a fifth, and we'll
Mhm.
just be sitting there drinking and talking shit. Cause I'll bring the fifth for like everybody, and then like nobody sits there and drink. I mean, they have their own stuff or whatever. But I bring a bottle because I want everybody to sit there and drink and have a good time and talk trash or whatever. You know what I'm saying? But like, yeah, everybody else bring their own stuff, so they end up drinking their own stuff. So it's like, well, I guess I'm gonna sit here and drink this bottle by myself. I guess you know what I'm
Whatever.
saying.
They're supposed to be joining you. One year, Mike was so drunk. He was like, well, I'm going to get ready to leave, but he was leaning. I was like, dude, sit your ass down. You're not driving nowhere. He's like, no, no, no. See, it's good that I drink. I can drive drunk because I can concentrate. I drive better when I drink. I said, sit down, Michael. Okay.
That's the standard drunk line right there. You know what I'm saying?
I'm
Drive
not
better when
going to
drunk.
that influence today.
Trade
No.
what I'm doing. You know what I'm saying? That's the classic right there.
Yep. I drink fine. I'm fine.
I'm a professional drinker, baby.
I'm fine. And he was just
Mhm.
leaning. He's like, oh, he feeling
But
nice.
I
Sit
made it
down.
home.
Yeah, we made you sit down for about an hour or two.
Uh-huh.
Well, Michael, I appreciate your big headed behind
Yeah,
coming.
yeah.
Um, and to look at box fort day. So we're gonna finish box fort day, and then we're gonna do COVID test. And
All right.
I technically could start showing this thing in chronological order,
Mm-hmm.
but I think it's a little bit more fun to skip, and I just pick my funny things. But you just had to see box fort day, so now you understand box fort day.
Well, I mean, like I say, like I'm pretty sure you have seen this trial probably back and forth a couple of times already. You know what I'm
Ad
saying? So,
nauseum.
like I said, all you have to do is just basically hit the highlights with me. You know what I'm saying?
Mhm.
So you're not just watching the same stuff over and over again. Like, yeah, like you said, pull out your favorite parts. You know what I'm saying? The ones that have notable names, like the box fort day and the
Mhm.
yellow shirt day and the brown shirt day, whatever. You know what I'm saying?
See, I need to show you the what is it, the autopsy, the medical examiner,
Mm-hmm.
and she was talking about all the people who got ran over, and
Mm-hmm.
when she got to talking about the little boy Jackson, she got teary eyed, and
Mm-hmm.
so when he's getting ready to give his cross, he just sits there
Mm-hmm.
like he feels something, and he's like, uh, "I'm sorry for the
Trying to
long
set up the
pause."
mood.
Yeah, he's trying to set the mood, but there was nothing there. There's nothing there. But we're gonna get to all of that. We're gonna get to some more fun days, so I can get some more of your virgin reactions.
Uh-huh. Yeah. Yeah.
All right, buddy. Well, it's time to go to bed.
All righty then.
I'm
Well,
old and you old.
yep. Yeah. So you know what I'm saying. I'm a peace out. So see y'all later, folks.
Thank you, Michael.
Mm-hmm.
All right. So that's it for this evening. I want to thank all of you guys for coming in and spending time with me to this evening. And those who came and spoke in the chat and those who didn't speak, I appreciate you guys for being here. And please feel free to leave your comments. I do read everybody's comment, even if I don't give you an actual response, but I read everything. So anyway, I really appreciate you guys so much. All right, well, let me get the hell out of here. And the last thing that I'm just going to say is drums, please.
Drums, please.